After the University of Idaho murders, particularly before Bryan Kohberger was arrested, the TikTok creator that we are talking about today was weaving fan fiction on social media regarding a professor from the University of Idaho and alleging that that professor had committed these murders and then had hired these murders and then was having an affair with one of these students. And then that's why she hired the murders, to have the affair covered up. And she doubled, tripled, quadrupled down, all the way down. She said that that was based on her intuition, her claircognizance, her psychic ability, and her tarot cards. Now, I have no problem with any of those things. I do have a problem with accusing people of murder with no evidence. That is defamation per se. The professor was left with no other option but to sue, decided to sue, and filed the lawsuit in federal court in Idaho. The original complaint was filed on December 21st, 2022. The TikToker decided to represent themselves in federal court, and it went to trial in federal court, and the TikToker represented themselves. This went to summary judgment motion. Different than a motion to dismiss, summary judgment looks at the evidence. Motion to dismiss, like a standard 12b6, early on in the case, looks at the four corners of the document. Is what you have alleged in the document, if everything you say here is true, do you have a cause of action? Like, if everything you say here is true, is there a case? That is a motion to dismiss four corners of the document. A summary judgment motion is based on all the discovery. After discovery happens, so summary judgment looks at all the evidence to find if there are any genuine disputes of fact. Could the jury look at everything that everyone's saying and say, could be A, could be B? The judge at summary judgment said there is no dispute of fact. You said what you said. What you said is defamation, period. So the case on liability ended at summary judgment. So what's left, Emily? Why did it go to trial? It went to trial on damages. How much damage, as we quantify it in an amount of money, did you cause? However, she still does not seem to perceive that the trial was only about damages, and not just about actual damages, but also about punitive damages, because it seems that she was continuing to litigate, and this happened in the pretrial motions, that she was continuing to litigate whether or not she was right in the things that she said. She has continued to talk about this on social media and say that the jurors are idiots, that they're biased, that they are impacting her First Amendment rights to free speech and freedom of religion. This just continued on and on and on and on and on until trial, and even during trial. And so we're going to look at the verdict filings, the filings after the verdict. We're going to look at all those things today. This is docket number 146, filed February 27th, special verdict form. Question number 1. Do you find by a preponderance of the evidence that defendant's false statements that plaintiff, see, when I tell you they had already decided defamation, it's in the verdict form. Do you find that the defamatory false statement that plaintiff had an inappropriate romantic relationship with a student damaged plaintiff? There's two defamatory statements. Did this defamatory statement damage plaintiff? Yes. State the amount of compensatory compensation damages. $1 million. Question 3. Do you find by clear and convincing evidence, two different standards, do you find by clear and convincing evidence that defendant's false statements that plaintiff had an inappropriate romantic relationship with a student warrant punitive damages? Those are the punishment ones. Yes. How much? $2.5 million. Question 5. Do you find by a preponderance of the evidence that defendant's false statements that plaintiff orchestrated the murder of 4 students at the University of Idaho damaged plaintiffs? Yes. State the amount of compensatory damages, $1.5 million. Do you find, by clear and convincing evidence, the defendant's false statements warrant punitive damages? Yes. How much? $5 million. $10 million total. It is possibly the largest individual defamation verdict that I have seen. We said 2026 was going to be the find out. This is the fucking find out. Docket 149. Judgment is hereby entered in favor of plaintiff against defendant TikToker for all claims contained in plaintiff's first amended complaint. Defendant shall pay plaintiff $2.5 million in compensatory damages, $7.5 in punitive damages. Done. So after the final judgment, the plaintiff filed another motion. Plaintiff's motion for attorney's fees. Having prevailed on summary judgment on her defamation claims and having been awarded $10 million in compensatory and punitive damages, plaintiff seeks her reasonable attorney's fees in the amount of $163,719.10 under FRCP 54D and Idaho Rule of Civil Procedure 54E and Idaho Code 12-121. Plaintiff's request is based on the records and files in this matter and the affidavit of attorney. The professor goes on to say that TikToker defended the case frivolously, unreasonably, and without foundation, that the actions repeatedly increased the cost of litigation. The TikToker, and this is true, the TikToker brought frivolous counterclaims, repeatedly challenged the court's jurisdiction, failed to meet deadlines, brought last-minute motions, including that motion to continue. Like, Your Honor, I just need more time. She repeatedly testified and admitted that her false statements lacked any basis in fact. Accordingly, an award of attorney's fees is appropriate. Attorney Olson billed her work at $400 per hour, well below her regular rates. The other attorney also billed at $400 per hour, also an amount that did not increase over 3 years of litigation. That is low. After the $10 million verdict and judgment, the plaintiff is asking for attorney's fees at a reduced rate of $163,000 plus. Hear me when I say that if you expect to do 3 years of litigation in a federal trial and pay $160,000, it is not realistic. This is a compassionate attorney that cared about this case and reduced their rate in this case for this plaintiff. I think there's grounds for it. I think the court can order it. They have not ruled on this yet. We have not seen an opposition filed by the TikToker yet. But that's just the motion for attorney's fees. Continuing on with costs. I am shocked at that amount. Professor respectfully requests the court award $1,700 in costs, $1,722.61. On June 28th, plaintiff incurred charges of $276 for a transcript of the summary judgment hearing. On December 21st, the plaintiff incurred charges of $402 for filing the complaint. And then travel expenses for the experts, meals for the experts that seem to be incredibly low. No hotel bills are in here. Incurred an expense of $381.81 for round trip airfare. Everybody was like, no, just book it as cheap as you can, which is generous because there are some experts that would never. $381.81 in airfare, $22 for meals, $30 for taxi, $297 for a hotel. So $700 for expert travel and meals. What is that? It's one meal? They didn't even that's not even an airport snack. It's so low. The statutory witness fee limit reimbursement of the travel and hotel expenses and mileage. The total round trip miles between Boise and Moscow is 574 miles at the statutory rate of 1.78 per mile. The reimbursement is $1,021.72. Thus, professor is seeking costs of $1,021.72 for the travel. Low amount of fees. But again, they're going to be in a position where the concern becomes, how do you recover these fees? And that's a very real issue here. However, these judgments can stick around forever. There is punitive damages here. There is the potential, of course, that the TikToker will try to make money in some other way and they can go after it then. But I think what they want is the TikToker to stop. I think that's always what they've wanted. And they're probably going to have to seek an injunction to get that to stop. There's a $10 million judgment out there, but if the other party sees it as monopoly money, what do? I mean, it helps with the headlines, but you're still not done litigating this. And we know they're not done litigating this because April 6th, we've got a new filing from the TikToker. The TikToker has filed their motion for relief of judgment due to fraud. The plaintiff lied about having damages. The allegation are false medical records, false damages, false witnesses, lied under oath. For these reasons, the entire case is fraudulent and a violation of the defendant's rights to a fair trial in federal and state proceedings, guaranteed by due process and the 5th and 14th Amendments. There are times when we see things on the internet and we go, why doesn't somebody just this? This is why. Why doesn't somebody just sue? This was filed in 2022. This is part of why people choose to not. TikToker goes on to say that the professor's complaint is founded upon the foundational lie that she was damaged. Just because you don't agree doesn't mean it's not true. The reason that defamation is a cause of action is because there are times that words said can cause such reputational damage that it needs to be accounted for, and dueling is no longer a thing. We have decided that there needs to be a less murdery way to deal with disputes. This goes on to say that the professor falsely claimed to have damages exceeding $75,000. The court has already addressed that in the past. Falsely claimed to have at least $1.8 million in damages, alleging that the TikToker's false statements caused promotion's leadership capabilities and salary increases to be jeopardized. Anyone who's worked in academia is going, that's exactly what happens. It goes on to say that the professor continued to lie about professional damages. I disagree. Filing documents of her attempt to continue to lie about having 10 years professional financial damages through the expert testimony of Dr. Rebecca. The court accepted professor's damages as true, and its decision and orders were all influenced by the foundational false claims of damages. That assertion is not factually based. Additionally, the TikToker alleges that the jury were also influenced by the foundational false claims of damages as reflected by the verdict for $2.5 million in compensatory damages that do not exist. The jury says it exists. She goes on to say that without the false evidence, false documents, and blatant lies, perjurious testimony of witnesses, she doesn't have a valid case. I'm sorry. So let's distill this into reality. Without her testimony and documents and evidence, there is no case. Correct. Without testimony, documents, and evidence, and filings, there is no case. I agree with that. I can agree with that. However, there is documents, testimony, and evidence. The TikToker goes on to say that the professor's lies about financial professional damages over $1 million throughout the litigation and during the trial were perjurious. In closing statements, I'm very interested in this. Their arguments, by the way. In closing arguments, Attorney Olson asked the jury to discriminate against TikToker. Oh, girl. During her closing arguments, Attorney Olson asked the jury to punish TikToker on behalf, of all quote unquote psychics for our spiritual beliefs because, quote, we can say anything if we believe it. I'm going to need the entire transcript, but I imagine most would say, we don't claim her. This isn't how you do it. The jury followed her request by punishing TikToker with $7.5 million in punitive damages without any evidence that TikToker made an intentional false statement with malicious intent. She goes on to say that, in fact, TikToker presented evidence that she did not make any statements about the professor with ill intent or knowledge of its falsity. She goes on to make the outlandish claim that it is more likely that the jury sought to punish TikToker based on her spiritual beliefs. This case appears to be a 2026 rendition of the Salem witch trials in 1692. Fucking hell. She says that she was targeted and punished for her spiritual beliefs, and false evidence, perjurious witnesses, and fabricated damages were used to render a verdict of $10 million against her. That's not what happened. You were not targeted. You targeted someone else. If you had responded to the cease and desists, it would have stopped, but you didn't stop. You went to a website and picked someone out and targeted harassment at them and defamed them. All of those were choices and actions. She says that her practices were even referred to as witchcraft, that the professor filed the complaint against her even though she lacked any damages. Disagree. Therefore, she had to lie and fabricate damages to justify the court's subject matter jurisdiction. That's been litigated over and over and over again. And to receive financial compensation. Defendant TikToker respectfully motions the court for relief from the final judgment of verdict. That's going to be denied. I can see that coming. Where are we at? We're at a $10 million verdict. We are now, it's not even doubling down. We are now digging a trench to hell to double down with the TikToker, well, making a motion to set aside the entire judgment based on fraud, saying all of this is just a lie. All the witnesses are lying. The medical bills are a lie. Everything's a lie. And then she compares it to the Salem witch trials, saying that she is being persecuted based on fabricated and perjurious evidence. That doesn't seem to comport with what happened in court or reality, but that is the filing regarding setting aside the judgment. What does that mean? It means the professor is going to have to respond to it. But wait, there's more. Because on April 6th, 2026, there was one more thing filed by the TikToker, and that brings us up to date on this docket. Notice of appeal from Judgement. Yep, notice of appeal. That has not yet hit the Ninth Circuit dockets, but she is noticing her intent to appeal. Emily, based on what? Well, I don't know. It's just here. The fight is not done, even though the professor won a definitive and resounding $10 million judgment against the TikToker. It still doesn't stop because she's filed notice of appeal. She's asking the court to set it aside, and the litigation cycle is just going to keep on going. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.